LLC.
Buenas tardes, estamos otra vez en actas en el caso número 22-21415.
You'll notice that there is an interpreter. Obviously, I'm going to get used to this for a moment.
Se dan cuenta de que hay un intérprete acá y claro, me tengo que acostumbrar durante unos minutos.
All right, as a preliminary matter, we are live streaming on YouTube.
Como cuestión preliminar, diré que estamos haciendo una emisión indirecta por el YouTube.
This is a program through the Administrative Office to increase access to justice to the public and allow the public to hear court proceedings.
Este es un programa de parte de la Oficina Administrativa de los Tribunales para incrementar el poder participar el público en las audiencias.
And the court takes the stance that today's hearing is a public hearing, so takes no issue with us being one of the test pilots.
Y por tanto, este tribunal halla que la audiencia de hoy consta de una audiencia pública y por tanto no tenemos ningún problema en que esta audiencia forme parte del programa piloto.
Argument will be streamed, but live testimony will not be part of the live stream.
Los argumentos sí formarán parte de la emisión en directo, pero el testimonio no formará parte de esta emisión en directo.
To the extent any party objects to today's proceedings being streamed on the court's YouTube channel, speak now. Otherwise, silence will be assumed as consent.
Si alguno de los presentes tiene protestas que presentar en cuanto a que se emita en directo esta audiencia, por favor, díganlo ahora, que si no, su silencio se tomará como que aceptan que se emita.
All right. Moving forward with today's docket, we have two matters on the court's docket. The first is the trustee's motion to sell, and the second is the sua sponte order that the court had entered in the last proceeding, and we'll get to that after the trustee's motion to sell.
Bien, tenemos dos cuestiones a mirarse hoy. La primera será el pedimento para vender de parte de la fiduciaria y la segunda será el pedimento sua sponte que se presentará después de que examinemos la cuestión de el pedimento de la venta.
All right, Mr. Bailey, this is your motion to sell the real estate. I have noticed that you also filed a amendment of sorts.
Señor Bailey, ahora el pedimento lo presentó usted para vender y también veo que ha hecho constar una enmienda, digamos.
Good afternoon, Your Honor. Jeb Bailey, the Chapter 7 trustee in this case.
Buenas tardes, señoría. Soy Jeb Bailey, el fiduciario del capítulo 7 en este caso.
Your Honor is correct. We had what I'll call an informal auction on Monday between the two highest offers that we had received for the property, which resulted.
Usted tiene razón. Hicimos lo que diría una subasta informal este lunes en cuanto a las dos ofertas más elevadas para la propiedad en cuestión.
Which resulted in an increase of the purchase price, but not a change in the purchaser.
Okay.
Resultó en un incremento en el precio de la venta, pero no cambió quién es el comprador.
Let's take appearances before we get into argument.
Háganse constar antes de presentar los argumentos.
And if we'll start from the left to the right.
Empezando de izquierda a derecha.
Jamal Walker on behalf of the Office of the U.S. Trustee.
The interpreter could not hear counsel.
Can you hear me?
The interpreter can hear now.
Okay. Jamal Walker on behalf of the Office of the U.S. Trustee.
Jamal Walker de parte de la oficina de la fiduciaria.
I'm Sean Haynes. I'm the Assistant U.S. Trustee.
Sean Haynes, soy el teniente fiduciario de los Estados Unidos.
Good afternoon, Your Honor. Cam Hillier on behalf of the Chapter 7 trustee, James Bailey.
Buenos días, señoría. Buenas tardes. Soy Cam Hilliard. Soy de la empresa de la fiduciaria de James Bailey.
Good afternoon, Carrie Ann Roshab on behalf of the United States Trustee.
Buenas tardes. Soy Terry Ann Rocha de parte de la fiduciaria federal.
Mr. Johnson, I see you on Teams.
Yes, I'm here, Your Honor. I'm Curtis Johnson. I'm appearing for the debtor Aras Business Group.
Señor Johnson, lo veo a usted por el Teams. Sí, buenas tardes, señoría. Yo soy Curtis Johnson y estoy aquí de parte de Aras Business Group, que son los deudores.
And then Mr. Weiner.
Y el señor Wagner.
Yes, Your Honor. I'm attending. I was on mute.
Sí, señoría, estoy aquí en asistencia. Estaba yo con el silencio puesto.
Marcel Weiner appearing for Preston Investment Group, LLC.
Soy Marcel Weiner y hago constar mi presencia de parte de Preston Investment Group, LLC.
All right, I believe that those are all the appearances, so Mr. Bailey, we can proceed with your motion.
Bien, señor Bailey, ya podemos proseguir con su pedimento, que creo que se han hecho constar todos en cuanto a su presencia.
Mr. Bailey.
Your Honor, this is related to docket number 150, the trustee's motion to approve the sale of the state's interest in assets.
Señoría, esto es referente al número 150 del orden del día, referente al pedimento de la fiduciaria en cuanto a los bienes activos.
And also docket 169 that Your Honor referenced, which is the notice of increase of sales price in a company.
Y también el artículo del orden del día número 169 con respecto al incremento del precio de la venta.
In the buyer's declaration attached thereto.
Y tiene adjunto la declaración de los compradores.
Your Honor, I would like to put Mr. Bailey on the stand.
Señoría, quisiera poner al señor Bailey en el banquillo de testigos.
Mr. Hilliard, if you'll pull the microphone a little bit closer to you so we can make sure that the interpreter can hear you.
Señor Hilliard, ¿puede colocar el micrófono un poquito más cerca a usted para asegurarnos de que la intérprete pueda oírlo?
Thank you. Mr. Bailey.
Gracias, señor Bailey.
Do you solemnly swear up or in the testimony
¿Usted jura solemnemente o afirma que el testimonio que está a punto de dar en esta bien, gracias.
Your Honor, the
¿Algo
trustee would request that the court approve the motion based upon the testimony of Mr. Bailey.
Señorita, pedimos que su señoría apruebe el pedimento basándonos en el testimonio prestado por el señor Bailey,
The declaration of Ms. Schaefer and the declaration of Preston Investment Group.
la declaración de la señorita Schaefer y la declaración de la Preston Investment Group,
And upon the motion and the notice of increase that were filed with the court.
y también el pedimento y la notificación sobre el incremento de del precio de la venta que se cursó ya con el tribunal.
And the lack of any objections.
Y visto que no hay protestas al respecto.
All right. The court is actually prepared to rule, and I have written something out.
Bien, me he preparado y he escrito una cosa.
I thought I would take a brief recess, but I think I'm ready to do this now.
Pensaba tomar un breve receso, pero pienso que estoy lista para hacer esto ahora. Your Honor, the interpreter would like to know if it would be easier for Your Honor to just provide the interpreter with a copy. I could read it into Spanish after you're done or something.
That would be wonderful. Maybe let's take a brief recess because I made some notes. So let me get the notes typed in, and then we can get this to you at the same time as I read it into the record. So let's.
Señoría, si usted quiere dar a la intérprete una copia, le puede leer después de que usted acabe.
1:55 will come back.
A la 1:55 volveremos y la intérprete tendrá una copia para leerlo en español después. Bien,
property free and clear.
estamos otra vez en actas con el caso de Aras Business Group y el pedimento para vender la propiedad sin obligaciones económicas.
And it took me 14
Retención.
additional minutes. So my apologies.
Necesitaba unos minutos más, les pido disculpas.
The court has emailed a copy of the written ruling to the interpreter, which I will assume that she will receive while I'm reading this into the record. And so I will not pause, because it might be painful to hear the ruling if we pause after
En-
each sentence.
He enviado una copia de este dictamen mío a la intérprete y supongo que ya lo está recibiendo. No voy a hacer ninguna pausa para la intérprete podrá leerlo después para no hacer esperar a todo el mundo. The interpreter has received a copy just for your honor's information.
Wonderful.
Thank
All
you.
right. This matter before the court is the trustee's motion to approve the sale of the estate's interest in certain real property, free and clear of liens, claims, and interest pursuant to 11 U.S.C. 363B and F and Federal Rule of Bankruptcy Procedure 6004. The proposed sale seeks to sell the estate's interest in certain real estate located in Prosper, Texas, consisting of a 29,000 square foot home situated on 6 acres of real estate with a physical address of 1400 Copper Point Road, Prosper, Texas, to Preston Investment Group, LLC, for the sum of $3,975,000. I'm going to call that the purchase price. This is a core proceeding under 28 U.S.C. 157B2A, M, N, and O. Accordingly, the court has both the statutory and constitutional authority to hear and determine these proceedings subject to the statutory appellate provisions of 28 U.S.C. Section 158A1 and Subpart 8 of the Federal Rules of Bankruptcy Procedure. This decision constitutes the court's finding of fact and conclusions of law under Federal Rule Civil Procedure 52, made applicable to this proceeding by Federal Rule of Bankruptcy Procedure 9014 and 7052. Regardless of whether or not specifically referenced in this decision, the court has examined the submitted materials, considered statements of counsel, considered the testimony given in this matter, considered all of the evidence, including all declarations submitted in this case, and reviewed the entire record as a whole. Based upon that review, and for the following reasons, the court hereby authorizes the debtor to accept, or the trustee to accept, the offer to purchase the property in the offered amount of $3,975 and proceed with the scheduled sale on August 31st, 2022. The underlying bankruptcy case has a relatively short history. On April 11th, 2022, the debtor filed the instant bankruptcy case as a voluntary case under Subchapter 5 of Chapter 11 of Title 11 of the United States Code. The case was quickly converted from a case under Subchapter 5 of Chapter 11 to a case under Chapter 7 of the Bankruptcy Code in late May of 2022. The debtor's interest in the property is property of the estate by virtue of 11 U.S.C. Section 541A. The court authorized the Chapter 7 trustee to employ Pamela Schaefer, a licensed real estate broker, to actively pursue the sale of the debtor's interest in the property. After marketing the property, the trustee received multiple offers on the property and ultimately conducted an auction resulting in the highest and best bid from Preston Investment Group, LLC, to purchase the debtor's interest in the property for the sum of $3,975. The executed purchase contract, along with the addendums, are attached to the trustee's notice of increased purchase price and declaration of buyer in support of motion to approve the sale of the estate's interest in the real property as Exhibit A. The court set August 22nd as the deadline for objections to the relief sought, and no objections were filed. The motion itself. A trustee has the power to sell property of the estate under 11 U.S.C. 363B. All sales not in the ordinary course may be by private or public auction. The Sixth Circuit follows the sound business judgment test in considering a sale of a debtor's assets Outside of the ordinary course of business, factors commonly considered include whether adequate and reasonable notice of the sale was provided to interested parties. 2, whether the sale has been proposed in good faith. And 3, whether the purchase price is fair and reasonable. See N. Ray Woodbury. I'm going to shorten my citations. They will be, the full citations will be in the filed opinion. McClung, and then also Woodbury. No one factor is determinative, and the court should consider all salient factors pertaining to the sale. The motion to sell the property has been adequately and reasonably noticed. The trustee has not only provided adequate and reasonable notice, but he has also addressed the court's concern that substantially all creditors are persons with limited English proficiency. The services of a Spanish-speaking interpreter were used to translate both the motion along with the order shortening time for this hearing. Both the English version and the Spanish version of the motion and order were mailed to all known claimants on or about August 12th. The trustee has provided adequate and reasonable notice of the sale to interested parties, and no party has filed an objection to said motion. The court also notes that additional safeguards were provided to interested parties and that parties could participate via Microsoft Teams in today's hearing, and the trustee used the services of an interpreter during these proceedings to ensure additional notice and access to justice to all parties. Next, the court finds that the sale has been proposed in good faith under 11 U.S.C. 363M. The purchaser is not affiliated with the debtor or otherwise related to any officers or members of the debtor. See Declaration of Preston Investment Group, LLC. The transaction proposed herein is the product of good faith arm's length negotiations. Lastly, the court finds that the purchase price is fair and reasonable under the circumstances. The transaction is supported by the sound business judgment of the trustee. The trustee submitted in his opinion that the offer for the purchase of the estate's interest in the property represents a fair and reasonable price for the assets being purchased. Furthermore, in Pamela Schaefer's declaration, she stated that she showed the property to approximately 25 purchasers. She further stated she received at least 4 written offers to purchase the property ranging from $1.7 million to $3.25 million with various contingencies, and ultimately conducted an auction. The bid submitted by the purchaser is the highest and best offer for the purchase given the dollar amount offered, it being an as-is purchase, and the lack of material contingencies, including the lack of an appraisal or financing contingency, and the product of lively informal auction the product of a lively informal auction between the highest bidders on August 22nd, 2022. The court heard testimony that the offer will result in fair and adequate value to the estate compared to the Scheduled A value and the January 2022 appraisal reviewed by the trustee. Given the current condition of the property, lack of utility service, and the frequent vandalism of the property, it also avoids maintenance expenses that would be borne by the estate. Instead, these considerable costs for a 29,000 square foot home will now be borne entirely by the purchaser. Moreover, no interested party has objected to the proposed sale, and it is the paramount interest of the creditors and proper deference to their reasonable views that also guide the court in determining that the value is fair and reasonable. In conclusion, for the reasons stated herein, the court hereby grants the trustee's motion to approve the sale of the estate's interest in the real estate, free and clear of claims and interest. The sale is proposed in good faith under 11 U.S.C. 363M, and the expedited sale of the property to the purchaser is in the best interest of the estate given the foregoing circumstances. The court waives the applicability of the 14-day stay provided in Federal Rule of Civil Procedure 6004H. Finally, the court approves the payment of the combined real estate commission of 5% to Ms. Schaefer and the buyer's agent collectively, the payment of normal and customary closing costs, the payment of the 2021 real estate taxes relating to the property, and the escrow of funds for the prorated 2022 real estate taxes relating to the property. And the court will prepare this order, and I will pause to give Ms. Hayes the time to read into the record the Spanish version. I would encourage you to omit the citations because it might be a little bit easier.
Ahora haré pausa para que la intérprete, señora Hayes, pueda leer en actas el documento que es mi respuesta al pedimento para vender la propiedad. Just for all concerned, this is going to take a little bit of time, so please bear with me. Damas y caballeros, ahora le voy a leer el dictamen de la juez. El Tribunal de Bancarrota para el Distrito Oeste de Tennessee, en el caso de Aras Business Group, LLC, el deudor, número de caso 22-214-15, capítulo 7, en donde se concede el pedimento de la fiduciaria para aprobar la venta de los intereses en determinada propiedad real sin retención económica y sin reclamación sobre intereses conforme a la número 11 del Código Federal 363 y el Tribunal de Bancarrota norma 6004, renunciando al plazo de tiempo de demora que se exige en la sección 6004. La cuestión ante el tribunal es el pedimento de la fiduciaria para que se apruebe la venta de los intereses del patrimonio sobre determinadas propiedades reales sin retenciones económicas, reclamaciones y otros intereses conforme a la 11 de las normas del Código Federal 366B y F y las normas para el Tribunal de Bancarrota 6004, que de aquí en adelante se dirá el pedimento. La venta propuesta tiene el objetivo de vender los intereses del patrimonio sobre una propiedad real que se localiza en Prosper, Texas, que consiste de una casa de 29,000 pies cuadrados situada sobre una propiedad de 6 acres con la dirección física de 1400 de la Copper Point Road de Prosper, Texas. De aquí en adelante que se dirá la propiedad, y que se venda a la Preston Investment Group LLC, el comprador, para la suma de $3,975,000, el precio de compra. Esta actuación judicial se realiza bajo el 28 del Código Federal, sección 157B2A, M y N y O. Conforme a ello, el tribunal tiene la autoridad legal y constitucional para oír y para determinar en esta actuación judicial, siempre sujeto a las disposiciones apelativas del 28 del Código Federal 158A1 y la parte 7, apelaciones en casos de bancarrota, de las normas federales en los procedimientos de bancarrota. Este dictamen constituye todo dictamen de este tribunal con respecto a los hechos y las conclusiones de ley bajo las normas federales en las actuaciones civiles 52 que se hacen aplicables a esta cuestión conforme a las normas federales para las bancarrotas 9014 y 7052. No importa si específicamente se había hecho una referencia a ello en esta decisión, el tribunal ha examinado los materiales que se han sometido, ha considerado las declaraciones de los abogados, ha considerado el testimonio prestado en esta cuestión, todas las pruebas, incluyendo las declaraciones que se sometieron en este caso, y ha repasado la integridad del acta de este caso. Y basándose en este repaso, y por las siguientes razones, el tribunal, con motivo de este documento, autoriza que el deudor acepte la oferta para comprar la propiedad en la cantidad ofrecida de $3,975,000 y que se prosiga con la venta que se haya puesto en el calendario para el día 31 de agosto del 2022. Fundamento fáctico. Subyaciendo este caso de bancarrota, hay un historial relativamente breve. El 11 de abril de 2022, el deudor inició este caso voluntariamente bajo el subcapítulo 5 del capítulo 11, del título 11 del Código Federal de Bancarrota. El caso rápidamente se convirtió en un caso que se vería bajo el subcapítulo 5 del capítulo 11, caso bajo el capítulo 7 del Código de Bancarrota a finales de mayo del 2022. El interés del deudor yace en la propiedad del patrimonio. One moment, please, Your Honor. I have to understand something. Estoy entendiendo una frase, un momentito, señores. Los intereses del deudor en esta propiedad son del deudor en virtud de la norma 11 del Código Federal, sección 541A. El tribunal autorizó que la fiduciaria de la bancarrota, capítulo 7, a que empleara a Pamela Schaefer, una broker de inmobiliaria con licencia, Schaefer, para activamente realizar la venta de los intereses del deudor sobre esta propiedad. Tras realizar la campaña de publicidad, la fiduciaria recibió múltiples ofertas sobre esta propiedad y, en último lugar, llevó a cabo una subasta que resultó en la mejor y más alta puja de parte de la Preston Investment Group LLC para comprar los intereses del deudor en la propiedad por la suma de $3,975 en efectivo, el precio de compra. Este contrato de venta se firmó junto con sus añadidos y se adjuntan en la notificación de la fiduciaria sobre el incremento en el precio de venta y la declaración del comprador que apoya el pedimento para aprobar esta venta de los intereses del patrimonio en la propiedad real. Esto consta como la prueba número 1. El tribunal fijó para el día 22 de agosto de 2022 como la fecha límite para que se presentaran protestas en cuanto a los remedios que se buscaban y no se hizo constar ninguna protesta. La ley y su análisis. Pedimento para vender la propiedad. La fiduciaria tiene el poder de vender la propiedad de este patrimonio, según la norma 11 del Código Federal 363B. Toda venta que no ocurra durante el transcurso normal de negocios se pueden presentar se puede hacer como mediante una venta privada o por subasta pública, según la norma 6004, normas federales sobre la bancarrota. Se cita, el sexto circuito sigue los propósitos, criterios comunes, sigue la prueba. Could Your Honor explain to the interpreter, the Sixth Circuit follows the sound business purpose test? I'm not understanding the phrase. Un momentito, señores.
It's probably a term of art. It's a sound business judgment, sound business purpose test, and that's a quotation from the Sixth Circuit. Does that make sense?
The interpreter's going to understand this as the Sixth Circuit follows the criteria in generally accepted criteria.
Sure.
Would that be all right?
That sounds good.
Thank you. El sexto circuito acepta los criterios que se aceptan de manera habitual a la hora de considerar la venta de los bienes activos de un deudor que ocurran afuera del transcurso normal del negocio de cada día. Los factores que se consideran comúnmente incluyen: 1, si se haya dado una notificación adecuada y razonable de la venta a todos los interesados, y 2, si la venta sea propuesta de buena fe, y 3, si el precio de venta es justo y razonable. Después se da una serie de citas judiciales que la juez ha omitido y que se podrán consultar en la publicación del documento, pero la intérprete no dará las citas numéricas. Este pedimento para vender la propiedad sí fue notificado a los interesados de manera adecuada y razonable. La fiduciaria no solamente les proveyó de la notificación adecuada y razonable, sino que también se ha ocupado de solventar las preocupaciones del tribunal que todos los acreedores sustancialmente son personas que tienen limitada proficiencia en inglés. Los servicios de un intérprete en español se usaron para traducir este pedimento junto con la orden que agiliza el tiempo para esta audiencia. Tanto la versión en inglés como la versión en español de este pedimento y de la orden correspondiente se enviaron por correo a todos los reclamantes conocidos en o alrededor del 12 de agosto del 2022. La fiduciaria ha proporcionado una notificación adecuada y razonable de esta venta a todos los interesados y nadie ha hecho constar ninguna protesta en cuanto a este pedimento de venta. También el tribunal hace destacar que se han tomado precauciones adicionales para que los interesados pudieran participar vía Microsoft Teams en la audiencia de hoy, y la fiduciaria usó servicio de intérprete durante esta actuación judicial para asegurarse que se dé notificación y acceso a la justicia a todos los interesados. Siguiente, el tribunal halla que la venta ha sido propuesta de buena fe según la norma 11 del Código Federal 363M. El comprador no tiene afiliación con el deudor ni tampoco relación con ningún oficial ni miembro de los deudores. Véase la declaración de la Preston Investment Group, y la transacción que se propone en este documento es el producto de buena fe y de negociaciones entre personas no relacionadas entre sí. En último lugar, el tribunal halla que el precio de compra es justo y razonable en estas circunstancias y que la transacción lo apoya el criterio de negocios, común de negocios, de la fiduciaria, y que la fiduciaria sometió a su opinión que la oferta del precio de la compra de los intereses del patrimonio sobre esta propiedad representa un precio justo y razonable en cuanto a los bienes activos que se comprarán. Además, según la declaración de Pamela Schaefer, ella dice que le mostró la propiedad a aproximadamente 25 potenciales compradores. Véase la declaración de Pamela Schaefer, documento 152. Ella dijo además que recibió 4 otras ofertas por escrito para comprar la propiedad, cantidades que corrían desde $1.700.000 hasta $3.250.000, con varias contingencias, y en último lugar se llevó a cabo una subasta. La puja que sometió el comprador es la más alta y la mejor oferta para esta propiedad, dada la cantidad de dólares que se ofrecían, y lo están comprando sobre el criterio de tal y como está la propiedad en este momento, y dada la falta de contingencias materiales, incluyéndose la falta de tasación oficial, o contingencia financiera y es producto de una subasta animada e informal entre los pujadores más altos el día de 22 de agosto del 2022. El tribunal ha oído testimonio que la oferta resultará en un valor justo y adecuado correspondiente a este patrimonio cuando se compara con el valor del itinerario A de la tasación que se realizó en enero del 2022 y que ha repasado la fiduciaria, dada la condición actual de la propiedad, la falta de servicios básicos, frecuente vandalismo sobre la propiedad. También evita gastos de mantenimiento que de otro modo hubiera tenido que pagar el patrimonio. En vez de ello, estos costes considerables para lo que es una casa de 29.000 pies cuadrados, ahora lo llevarán íntegramente el comprador. Además, ninguna persona interesada ha presentado protestas en cuanto a la venta propuesta. Sirve los intereses más altos de los acreedores y respecta de manera adecuada sus puntos de vista razonables. Bard contra Schicherman, y se da la cita del caso, que también guían el dictamen del tribunal a la hora de determinar que la oferta sea razonable y justa. Conclusión. Por todas las razones recogidas en este documento, el tribunal, con motivo del presente, concede el pedimento de la fiduciaria para aprobar la venta de los intereses del patrimonio sobre esta propiedad real sin retenciones económicas, ni tampoco reclamaciones ni intereses de terceros, conforme a el 11 del Código Federal 373B y F, según la norma 6004 en los casos de bancarrota. Esta venta se propone de buena fe, según la misma ley, y la venta agilizada de esta propiedad al comprador cumple los intereses del patrimonio dadas las circunstancias anteriores. El tribunal renuncia a la aplicabilidad del periodo de espera de 14 días que se describe en la ley sobre la bancarrota 6004H. Finalmente, el tribunal aprueba, 1, el pago de la comisión combinada de la agencia de inmobiliaria de 5% a la señorita Schaefer y al agente del comprador. 2, el pago de los costes normales del cierre del trato. 3, el pago de las tasas sobre el terreno del 2021 correspondiente a esta propiedad. Y 4, la cuenta de la plica de los fondos prorrateados para el 2022 correspondiente a los impuestos sobre el terreno que se relacionan con esta propiedad. El tribunal, la Secretaría del Tribunal de Bancarrota causará que una copia de esta orden y notificación se envíen a las siguientes personas interesadas y después se hace una relación de las personas nombradas. The interpreter has finished the reading of the document but has not read out the names and addresses of the persons, interested persons. That's not necessary, is it?
No, it is not. Thank you.
Thank you.
All right, so that concludes the motion to sell, and so I'm showing that as granted, the order will be prepared by the court.
Con esto se concluye el pedimento para vender y estoy viendo que ya se plasmó en la orden del tribunal.
I may wait for the language. It seemed like you were wanting some language, specific language.
That's correct, Your Honor.
Estoy esperando a que se incluya algún lenguaje de parte de ustedes, ¿correcto? Sí, correcto, señoría.
How about I provide the court's order to you, and you can work with the Texas Taxing Authority.
¿Qué tal si yo le proveo a usted la orden y entonces usted a su vez puede trabajar con las autoridades impositivas del estado de Texas con respecto a esto?
All right.
Thank you.
Wonderful.
Bien, perfecto.
All right, the other matter on the court's docket is the order that is regarding the interpreter for future hearings and today's hearing. And I kind of want to pause the interpreter so we can have, I want a little bit more of a conversation still about how to move forward and make sure that we are providing what I see as potential access to justice issues to individuals with limited English proficiency.
La otra cuestión pendiente ante el tribunal es la cuestión de la orden referente a la interpretación y quiero hacer una pausa para ponernos al día de asegurarnos de que estemos proveyendo a las personas que tienen limitado idioma inglés que tengan acceso al proceso judicial.
So, on the court's docket is a notice filed by the U.S. Trustee's Office that is a notice of limited English proficiency resources available through the United States Trustees Program.
Aquí lo que tengo es una notificación de parte de la fiduciaria federal acerca del acceso al programa de recursos para las personas con limitado inglés.
I've read it.
Me lo he leído.
I don't like it. I don't like the answer. Because
No me gusta y no me gusta la respuesta, les diré por qué.
I look at the primary role of the United States program. United States Trustee Program is to serve as the watchdog over the bankruptcy process.
Yo miro el programa, la razón principal de su existencia es un proceso, digamos, que hace de perro guardián sobre el proceso de bancarrota.
As stated in the United States Trustee Program mission statement,
Tal y como se dice en la declaración de la misión de la fiduciaria federal,
it says the mission of the United States Trustee Program is to promote the integrity and efficiency of the bankruptcy system for the benefit of all stakeholders.
se dice que la misión del programa de la fiduciaria de bancarrota federal es promocionar la integridad y la eficiencia para todos aquellos que tengan interés en un caso de bancarrota.
It goes on to say debtors, creditors, and the public.
Dice deudores, acreedores y el público.
To further the public interest in a just, speedy, and economical resolution of cases filed under the Bankruptcy Code.
Para promocionar el interés del público de una manera justa y, Your Honor, the interpreter would ask that you go back and read that part and just break it in half for the interpreter.
To further the public interest in the just, speedy, and economical resolution
Para incrementar el poder participar en los miembros del público en una resolución justa y rápida
of cases filed under the Bankruptcy Code.
de los casos que se formulan bajo el Código Federal de Bancarrota.
So I give you your own mission statement.
Yo les doy su propia declaración de misión.
You can't help individuals in this case that are
Que-
the most interested people in this case.
Se trata de que ustedes puedan ayudar a las personas quienes más interés tienen en este caso.
And Your Honor, I think what it comes down to, as I understand the nut we're trying to crack, is who's going to pay for those services. And
Señoría, pues según yo entiendo, lo que viene siendo la cuestión, ¿quién pagará estos servicios?
the Memphis field office, is directed by the policies of the Department of Justice as expressed to the Executive Office for U.S. Trustee, the U.S. Trustee Program. And so that is the policy, and that's
Your
how
Honor.
those decisions.
You may have to break up your statements.
La oficina local de Memphis se tiene que acatar a las directivas del Departamento de Justicia. The interpreter's gotten as far as the Department of Justice.
As those policies are specific to the U.S. Trustee Program,
En cuanto a esas políticas que sean específicas en cuanto al programa sobre la fiduciaria federal.
and as I understand that policy, it robustly and broadly implements what the relevant executive order says to do.
Tal y como yo entiendo esa política, robustamente y ampliamente implementa lo que dice la orden ejecutiva, cómo tenemos que hacerlo.
Which is to provide
Lo cual es proveer
limited English proficiency
interpreter would ask counsel to go on a little bit longer.
which is to provide limited English proficiency services
Para proveer servicios a las personas que tienen limitado inglés
for programs and proceedings of the Department of Justice.
en los programas y los procedimientos que toman lugar dentro del Departamento de Justicia.
And as the notice that we filed states, that applies to the main bankruptcy programs of the Department of Justice.
Y como se hace constar en la notificación que nosotros cursamos, esto se aplica en los programas principales del Departamento de Justicia en cuanto a la bancarrota.
The meetings of creditors,
The interpreter did not hear, counsel.
the meetings of creditors,
Las reuniones de los acreedores
and agencies that provide credit counseling and debtor education services.
y las agencias que dan sesiones de orientación en cuanto al crédito y servicios a los deudores.
And I know in our last setting, my recollection from the last setting,
Recuerdo de la última vez que se celebró una audiencia con respecto a esto.
there was a discussion about the clerk's office itself funding the interpreting services needed for court proceedings.
Se conversó acerca de la posibilidad de que la oficial, la secretaría del tribunal diera los fondos para que se llevaran a cabo el servicio de interpretación.
Would not be the clerk's office. When you say the clerk's office, I assume that you mean the bankruptcy clerk's office. They do
No
not
sería la
have
oficial, no, go ahead.
earmarked for such services.
Did your honor say do or do not have?
Do not.
Cuando usted dice secretaría, supongo que está refiriéndose a la secretaría del Tribunal de Bancarrota, pero bueno, en cualquier caso, ellos no tienen fondos establecidos para proveer esta clase de servicios.
Potential funds would be from the district court.
Potencialmente los fondos podrían venir del Tribunal Federal de este distrito,
But I want to make sure that I exhaust every avenue I have potentially available first.
pero quiero asegurarme de que primero yo agote todas las avenidas de acción que yo tenga a mi alcance primero.
And my question for you is, did you reach out to any of your brother U.S. trustees that would be in California, Arizona, or Texas, where they may have come up with this issue before?
Mi pregunta que yo tendría para usted trató de hablar con alguno de sus prójimos que realizan las mismas actividades de usted, pero en sitios como California, Arizona y Texas, en donde puede haberse hallado con esta situación anteriormente.
We did.
Sí,
And they all said no.
y dijeron que no, todo el mundo.
Mr. Walker was the one who did that outreach, and unfortunately, as a personal appointment,
El señor Walker fue quien hizo ese esfuerzo, pero desgraciadamente tenía una cita personal, no pudo estar aquí hoy.
he reported back to me that, for example, one office that has many Spanish-speaking stakeholders, and there was
Él sí que me dijo, después de haber hecho el intento, que había una oficina que tratan con muchísimas personas de habla hispana, muchas personas con intereses en casos.
There was nothing obvious that we were missing in terms of our understanding of funding for translation services.
Y no había nada obvio que nos faltaba para examinar en cuanto a buscar fondos para servicios de traducción.
So I'm wondering if the trustees' stance is it's only for programs that they are the ones running. Do I
Yo me preocupo.
limit the trustees' participation in hearings because they are not willing to also fund the interpreter?
Yo me pregunto entonces que si esta cuestión surge en casos en donde está la fiduciaria federal, pero que ellos no están dispuestos a proveer servicios de interpretación, ¿esto quiere decir que tengo que limitar la participación de la fiduciaria?
I just don't like the answer.
Simplemente no me gusta la respuesta.
Debate about this and be paused a lot. I suspect I know what your answer is always going to be, and I wish that Mr. Walker was still in here to tell me what he learned from his other U.S. trustees from other offices, because I am not the first court to have dealt with this.
Ojalá el señor Walker no hubiera tenido que irse de aquí y pudiéramos hablar con él del tema, porque sospecho que sé cuál será la respuesta de ustedes, que seguirá siendo la misma, pero yo quisiera hablar con él, a ver que me diga él qué es lo que había conversado con estas otras personas, porque seguro que yo no soy la primera juez que haya tenido que tratar este tema.
So I'm not dropping this yet. So
O sea que este tema no lo deja descansar todavía.
I want to see the U.S. trustee also looking for ways to read into their policies.
Quiero ver que la fiduciaria federal haga el esfuerzo de leer e interpretar sus propias políticas.
I am going to go to the district court to ask for money so that the clerk's office has the ability to translate their notices to send those out.
Yo voy a dirigirme al tribunal del distrito para buscar fondos para que al menos la secretaría tiene fondos para hacer traducir la documentación de notificaciones, etcétera, en este caso, para que la gente pueda tener acceso.
And now I'm looking at Mr. Bailey because I want to hear ballpark figure as to what today cost.
Y ahora le miro al señor Bailey porque quiero saber una cifra aproximada acerca de qué es lo que costó lo de hoy.
Your Honor, Cam Hillier for Trustee James Bailey.
Señoría, Cam Hillier de parte de la fiduciaria James Bailey.
I handled most of that.
Yo me arreglé la mayoría de eso.
For the initial translation of the notice of hearing, the motion, the exhibit, and the declaration.
Para la traducción de la notificación original, el pedimento, la declaración.
I believe that was just for those documents, and the certificate of accuracy is what costs money to get it from a certified translator.
Creo que para esos documentos solamente, y además el certificado de precisión, que es lo que cuesta el dinero.
I want to say it was close to $600.
Quiero decir que sea aproximadamente a unos $600.
Which the estate bore, we're talking about a $4 million.
Right.
Y que el patrimonio es quien cargó con esto, y estamos hablando que fueron unos $4 millones.
The interpreter I contacted her maybe last week. Ms. Roshab gave me the list of interpreters, and luckily she could appear on Teams.
Yo me puse en contacto con la intérprete la semana pasada, la señorita Rosas, quien me dio la lista de intérpretes, y por suerte ella pudo hacer la comparecencia por Teams.
I believe she is in Cookville, and there was no one in Memphis, no one in Jackson, Mississippi, over, and the only other person in Nashville referred me to her because she didn't do it anymore. So that is our interpreter.
Y no hay nadie en Memphis, ni en Jackson, ni tampoco la única persona que había en Nashville. Esta intérprete se encuentra en Cookville y la de Nashville nos remitió a ella porque ella simplemente ya no hace esto.
As to that, I did not read the terms and conditions line by line because we had a lot of stuff with the auction closing, getting to here, but I do know that they were very reasonable, but I believe services are minimal, have to be a minimum you get charged for a half day.
En cuanto a los términos y condiciones exactos, no pude leérmelo todo, pero porque teníamos, entre otras cosas, pues el cierre del subvasto y un montón de cosas que pasaban hoy, pero sé que sí que eran muy razonables. Me suena que había como un mínimo de la mitad de un día.
But there's also the question, the interpreter was nice enough to give me the list. They have, as the approved interpreters, they have contracts with the government. So if the court itself or the United States is not, well, I believe the interpreter's here, she can answer, there's a different rate for the courts.
Pero la intérprete fue suficientemente amable como para darme la lista oficial de los intérpretes y tengo entendido que, y ella, la intérprete está aquí, le puede contestar algo, pero que tengo entendido que hay una tasa oficial diferente si lo está pagando en los tribunales.
And I don't know, and cannot speak, whether that is the same rate that is given to a U.S. Attorney's office or a United States Trustee's office or to the court itself. I do not know. But the interpreter.
Y en cuanto, y yo no lo sé si es la misma tasa que cobra la intérprete, tanto sea la Fiscalía Federal como sea el Tribunal de Bancarrota, que sea otro tribunal, no lo sé.
I also do not know how many people we have on the phone line today.
I've been watching that.
Tampoco sé cuántas personas tenemos en la línea del teléfono ahí.
You know, that would help me decide whether or not we needed to do this in the future. Cost is in my mind. And so I'm trying to see and think through what other potential motions may be filed.
Yo lo estoy pensando también y lo he estado echando ojo a ver cuánta gente había, porque claro, estoy pensando en los costes, los gastos, cuántos pedimentos se tienen que haber hecho constar en el futuro.
Before you get to that, do we know if there are any other assets, let's say in Shelby County?
Antes de que llegue a ello, ¿sabemos si hay algún otro bien activo en el condado de Shelby County?
Could you repeat the question?
Are there
¿Puede
any
repetir la pregunta?
anticipated sales?
¿Hay otras ventas anticipadas?
There is one that I'm aware of at the moment. It is a 2,100 square foot house.
Que yo sepa, hay una que se piensa, en el momento es una casa de 21,000 pies cuadradas.
It's in Bartlett, yes, Your Honor.
The interpreter could not hear, counsel. It is what?
It's in Bartlett, Tennessee.
Está en Bartlett, Tennessee. The interpreter would like to inquire as to how much longer the hearing might last because due to mental fatigue, interpreters are really not to do more than 1 hour at a time if they're doing this. I
think that what is left, we don't actually have to have the interpreter. I'm trying to get a better understanding of when we need an interpreter in future hearings, and to anticipate how much I need to be asking for from district court potentially. So if we have another 363 motion, Ms. Hayes, I really do appreciate your time and all that you have done today. And so to the extent you want to drop from the line, you are excused, but you are welcome to stay and participate if wanted, but I do not need any more interpretation of what I'm saying. So
thank you very much, Your Honor. Let me just say before you go on to the next, I'm sorry to interrupt you. If I participate, it kind of interferes with my ability to be the interpreter of record then, because then I'll be a witness for it. So I think I'll keep my mouth shut, but I'm going to take some notes,
okay.
if you like, and I might have ideas to tell you later.
Okay. Wonderful. Because again, this is new for lots of people in this room, maybe Mr. Bailey, because of his involvement in the Puerto Rico case, you probably have an edge on the rest of us. But so if we have a 363 sale, another one, which isn't as big.
It's nowhere. It's a rounding error.
Okay.
In comparison to this.
Then you have potential objections to claims. Is there anything else that you anticipate?
Very well. There very well may be some adversary proceedings. I mean, there are going to be claims that I'm still evaluating whether they are viable claims to pursue or not. But there's the potential for additional litigation.
Okay, I kind of put those in a different pool because, well, it depends. I guess that they would be benefiting the estate, so maybe the estate would potentially be.
I can give you an example. There was a failed purchase transaction that the company had entered into to purchase some property in Florida. As a consequence of that transaction, the failure of that transaction, it lost a $300,000 deposit. And so I want to look at that and see whether that is a potential fraudulent transfer that could be recoverable. But that wouldn't necessarily involve anyone until we got to either a trial of the matter or a potential settlement, in which case we would file obviously a 9019 motion, and that might be something that creditors, but outside of that, if the trustee's just pursuing litigation against third parties, I don't know that would in and of itself, necessitate an interpreter for those things. And by the way, just so the court's aware, despite the billions of dollars at stake in in the Puerto Rico case, none of the hearings were conducted in both languages, as far as I know. So that's, I certainly want everyone to have access and understand what's going on in this, but it's also that there's also a balance, I think, that has to be struck, and that's on a case-by-case basis, I think.
And I think what we do going forward potentially would be a motion by motion, depending on the motion, the interested parties, who's the interested party. I really would love the U.S. Trustee's office to step up. I may not be able to get my way. So I just don't want the money that just came into the estate to be used for translation when I feel like there should be services available already. So I will continue to look for money and services through the district court. And then the other thought that I had was, I had brought this up to you, Mr. Bailey, was whether or not the SEC was going to be involved. And sometimes I know that a government agency can step into the shoes of certain creditors, and I wondered if that happens, then I know that I can point to the administrative office and say, you pay for these. But again, I did say I didn't know how excited that made the trustee in this case, because sometimes that may create additional work. But and of course we don't know if they're going to file a claim, because their claim deadline is not for a while.
Correct. And I apologize, Your Honor. I need to have several conversations with the counsel for the SEC over several matters, but I have not yet. And so, and that's my fault.
Well, it doesn't sound like there's anything that needs to be expedited at this point.
No, not that I'm aware of.
And I hope that you.
This was my biggest.
Yes. I know that this was a unique situation at the moment, and to the extent that you need the court, obviously, the court is always available to you. And we will, from this point, just take it a case-by-case basis or motion-by-motion basis. I am interested to see how the proof of claims process is going to shake out, and so that's probably what I'm trying to think about at the moment.
That's why I stood up, Your Honor. I'm sorry, I didn't mean to take his spot.
More than welcome to.
Taking all of his calls, the trustees' calls, or being forwarded to me, of the 400 notices in Spanish and English that went out, I got one phone call about this sale motion, one. And that phone call was, how quickly were we mailing out the money?
Yep.
And that was just a typical, and I say that with some levity that I explained. But for that is one, for what we went through to translate it, not knowing, but at the same time, I understand where the court is at in the balance. It is all claims driven. That no call is not about claims. 5 calls a day, claims. I don't know to do claims. It's not about whether or not, whether it's the trustee or counsel for the trustee or anybody else saying you shouldn't care about this, where the actual result is no one cares about, up to this point, anything that has happened on. No one has moved off the claim. I believe we said it was 137 claims that have been filed, and that's not the 5 people that are calling me every single day. Those are people that haven't filed claims. So it's 137 and 5, 10, 50 a week, and then those are the claims that Your Honor is seeing hit, because I can look at the name and I know that's who called me yesterday, and I had to explain to them to go to the link on the website that you don't have to mail it in. Please stop it mailing them to Mr. Bailey. I can't give you advice about filling it out, but I see the names, and it's every call results in that with oral instructions on how to do it. That is literally going to, on a balancing test, just in my opinion, that is literally going to be versus an interpreter to hearing on a sale of a house or a 505 AP motion about taxes. It's all going to be claims driven, and I think everything has been done very reasonable up to this point with whatever resources that we have.
Good morning, Your Honor. Carrie Ann Roche, the United States Trustee, and I'm going to speak a little bit as to what the Chapter 7 Trustee Council and I have spoken about with respect to trying to get the most benefit to the parties that need it, and also in speaking the last time we were in court with someone who was here, and I think that's what Mr. Hillier is just speaking to, in that we're not so sure that the interpretation services of these general hearings is really benefiting these creditors, because just as with speaking English and going out on the street and talking about proofs of claim or bankruptcy or things of that nature, a normal English speaker would not understand what we're saying. And that was our representation when we were in here last, and there was someone here who did speak English and was with someone who didn't speak English, and they need representation, not necessarily interpretation. And so the United States Trustee and the Chapter 7 Trustee can't provide representation to them to explain those things to them. And so that's really what we think is the crux of the concern of the court as well, that they have someone to explain this to them. And none of us, the court cannot explain this to them necessarily as to give in the form of giving them legal advice. The United States Trustee can't explain that to them, and the Chapter 7 Trustee, as counsel for them, can't explain that to them. So we had, Mr. Hillier and I have spoken several times about some way that we could make a motion to, or the trustee could make a motion to Your Honor that would provide something where we could explain that claims process in the form of a motion. And that may be the one thing that we may need to only interpret that document as the last thing that we do, and we don't continue to accrue more funds interpreting additional things from the estate, which would only deplete the funds in the estate that would go out to these creditors. So the benefit of whether they're getting enough benefit from what we're doing for them. And so we had discussed some type of motion, if Your Honor would entertain that, that would provide for an interpreted claim form and a motion that gave somewhat of a description of the case, and give that something like that out there. And the United States trustee is obviously limited by the policies that we have from doing that, but that in discussions, perhaps that would be a limited estate cost that would be also beneficial to the estate, because it would get claims coming in that could be paid by the trustee, and it might get better claims and the quality of claims, so it could reduce administrative costs and possibly make it worth it to the parties to make that motion and interpret that document. So that is something we have discussed, and I think maybe if we're discussing, we could loop in Your Honor if you would think that would be beneficial, instead of trying to give this limited interpretation where we're not providing any representation.
Right. Okay.
I believe the claims deadline's already been extended once. Is that right? And then obviously, if we're playing hot potato, the idea of instructions or whatever, but I just thought about the next 100 claims come in Spanish. And what does the clerk's office do about, we have 130 claims, and the claim form must be submitted in English, but they submit them in Spanish, and then we have half our claims in English, half in Spanish, and what that means, on translation of secured, unsecured, does it mean feel
Right.
good, not good? I just don't know, but I do know that it would, like a general update, like if literally we had, and somebody called me and they said, we've been called, Mr. Bailey was chuckling, the guy called and said, we've been told to call the Lux Man. And I was like,
I wondered if some of that was happening.
and I'd give people their name. Representing 10 Hispanic speaking families, 15 or whatever. So I've been trying to help them as much as I can without legal advice, and they're passing around names, but a lot of families don't know a lot of. They're not all in Texas. Claims come in from people in Ohio, but they all are vast majority Hispanic. So it's kind of like you wish you could just send out a news blast of, if you missed this. But if you're talking about sending out a motion, I don't know, when is the claims? August?
I believe it's September 9th.
September
That's the
9th.
date that's
It's right.
in my head.
And they're still calling and they're not.
So, when you ask if a claim is being filed in Spanish, so I took the stance, at least in the last hearing, that between the English and the Spanish version, that the English trumps. So any conflict between the two, the English trumps. I think all the attachments to the proofs of claim, a lot of them are in Spanish, but I can see your point of if the proof of claim is written in Spanish and then that's what they send back. I think I'm still gonna let the party still work on, I don't know how involved I really want to be in the claims process because it's not really before the court. I see that as an issue, but I don't want to meddle. I don't think it's my job to meddle at this point, and so a claim as filed is allowed unless the trustee objects to it, and so I'm gonna take that stance. And then, to the extent that, the parties need the court or see an issue, it sounds like the parties are talking about some of the issues. I don't wanna get too involved, just because the claims process, there is a claims process, and I wanna follow the claims process and not get too far down a rabbit hole.
And we're mailing we're mailing them now, or hand delivering them. Mr. Bailey gets 4 a day in FedEx, United States Bankruptcy Court, care of James Bailey, and it is the original signed proof of claim, and we are getting the proof of claims down to the court, unredacted form with driver's licenses in there and everything. But the hard part is what Ms. Rorschach talked about, is somebody basically saying, I'm not a creditor. I'm an owner. I think I bought some, and I'm just like, I can't even. I can't discuss that
Well,
with
the
you.
person in the courtroom a couple weeks ago.
He thought he owned.
A victim is the word that they use, so.
Right.
Yeah,
But
again, to me, part of that is claims process, and I've tried to be careful on what word I use for each individual, because again, it could be investor, owner, member, I don't know. And again, I don't think I should be, I think that's Mr. Bailey's job to look at the claims register.
There should be some set off to the extent of, I'll tell you this, for the vast majority of those phone calls with those people, I do not record my time for that, for the state to bear that expense of me talking to a child, translating for that. But a lot of times it will go on, and just because with the other authorities, but to the extent that it doesn't stop and it is taking up a tremendous amount of time, to the extent it is a very nominal cost, or even not a substantial cost to the estate to get something out in Spanish that says use this form or something like that, then it to the fact that if it saves Mr. Bailey or me four or five phone calls, and that totals up to an hour a day, trying to be polite to the people that you or the they call themselves victims, they always do. That in and of itself is a substantial cost when you're talking about 20 hours a week, or 20 hours a month, or whatever. If it's just getting a mailing out there, if that stopped that, that's very self-serving for me to say, because I don't want the phone calls, so I can do other things. But it is a significant offset to if they're calling the clerk's office. I know half of them have said they can't get through the dial-in on the clerk. They're calling your clerk, the actual clerk's office, and trying to find people and leave messages. I don't know if they get through. They seem to get through to my direct dial that Mr. Bailey left on his voicemail a lot faster. So that would be just cost benefit, and will continue to work. But I think for this hearing, you're probably totaling all in. That's why when Ms. Hay dropped up, probably totaling all in for the interpreter and the translation, between $1,000 and $1,200 or less just for this. And thank goodness we got the sales price of $700,000 to do that. But I also don't know what it costs to mail out English and Spanish, like volume wise. I guess that's a duplication of every mailing. I guess you cram it into one envelope.
Well, we're working on that issue too, is to make sure we're not doing two mailings, like going back and basically remailing the exact same things that happened the day before. And so I have put the clerk's office just to push pause at the moment on what we do for whenever we do have translation. I have another thought. If this was a chapter 11. But I don't know that Mr. Bailey has access to documents, and maybe that's part of the problem, but I'm just thinking of it in a chapter 11, the scheduled amount would be the claim amount unless you file a claim, or it's.
But the schedules only had
They didn't have.
20 creditors listed, scheduled.
And Mr. Johnson's on the line just smiling, so.
That doesn't help a whole lot.
Right.
So we're going to take a pause for a moment. I think Ms. Hayes is about to drop off the line, and there's a question whether or not she needs to be sworn in. I read the rule to say we did not need to swear her in unless the witness was speaking Spanish, but we're going ahead and swear her in retroactively just in case. And so, Mr. Joyner and Ms. Hayes.
Ms. Hayes, can you hear me?
Yes, ma'am.
Do you solemnly swear or affirm that in this proceeding you will truthfully and accurately interpret and translate into Spanish to the witness all questions put to him, her, or them, and will truthfully and accurately interpret and translate into English the responses of the witness to the best of your skill and understanding?
I do so swear, and I also swear that even if there were no witnesses, the interpreter has translated to the best of her ability English to Spanish and Spanish to English during the proceedings.
Thank you, Ms. Hayes.
Thank you. I'm going to disconnect, if that's okay.
All right, thank you. So we were talking about if it was a Chapter 11, then the scheduled amounts could be the claim amounts. Mr. Bailey is shaking his head, and I understand.
No, that's true. The problem is there just weren't hardly any creditors listed on schedules D, E, or F.
I'm just,
Your Honor, if I could add one comment to that. I think that at the time we had some informal conversations and we were trying to figure out on our end how many creditors there were. And so I think we have a better understanding of that universe of creditors now. But I think I provided to Mr. Bailey as well as the SEC a spreadsheet of all of the known investors. So I think that
how many
I think
were
we
on that sheet of paper?
it was about in between 300 to 400, if I am correct.
Yeah. Which I think is consistent with the list of equity security holders that was filed. It seems like that information the list of equity security holders was derived from that spreadsheet. But that doesn't solve the problem about if the claim is scheduled and not disputed, contingent, or unliquidated, that it's deemed allowed, or deemed allowed.
Or the SEC files a claim on behalf of the claimants.
That would, haven't thought through all that, but that would sure be easy to make one distribution to the SEC.
Yeah,
instead
and
of
then,
me having to
and
write.
then they get to distribute.
Let them do.
I'm thinking about a case that I was involved in that also had the government as a potential proof of claim. We ended up, using the claimant's proofs of claim. Of course, they were scheduled in the Chapter 11, but the government was involved. They wanted to check the claims registrar before their deadline because they potentially represent all those claimants too. So it may be a thought, but I know you're very smart, and this is definitely your job, and you're gonna earn your fee in this one. It's definitely unique. I do see the proof of claim as the other potential language barrier, and then I just thought today was too much money, and the unknown of who is an interested party and what kind of interest do they have.
You mentioned that you could tell how many people.
There were 8 or 9 people jumping in and out.
Oh wow, that's all. Okay.
So not that many. There are still people on the line, but I can just tell phone numbers are there.
Mm-hmm.
So not that many.
You know, if we get into if we get into the claims objection process, if I look at a claim and say I need to object to it, then I think we fall into the I forget now that statute and that Your Honor had initially referenced me to. And I think it said, that if a party requests those services, but they have to do it at their expense,
Unless the government is a party.
unless the government is a party, correct. And apparently I'm not considered, which is fine. I'm not considered the government anymore. I used to be. but 100 years ago.
Which still gets me to, well, if the SEC was the actual one
Mhm.
representing, then you would have an interpreter at the expense of the administrative office. It's just food for thought. I will still work on getting some money. But I think what I want to do is probably limit, we'll go back to just English version of notices unless and until the proofs of claim allowance process is in process, or to the extent that the trustee, Chapter 7 trustee and the U.S. trustee believes that maybe additional notice needs to go out to help individuals file proofs of claim. Otherwise, I will assume that the SEC will do their job and represent the individuals that they represent. So, an interesting one. Thank you for your time.
No doubt.
And I'll work with the taxing authorities as soon as I
Okay.
get your order to plug in whatever makes them happy.
I heard that during an argument. I was like, uh-oh, they're not gonna like my order.
It's really just gonna be an issue of,
The 2022.
does the buyer want to escrow the second prorated half and have all the 22 taxes in an escrow account where the lien attaches to the escrow, then the property can say free and clear of all liens, claims, and encumbrances? Or do they not want to kick in money to the escrow account, which would mean the lien would stay on the property and stay on the escrow proceeds just until October 1, or frankly, after they close, they're responsible for the second portion. They could wait all the way up to January 29 of 2023 with the money in the, once we got the reduced tax amount, we would immediately remit it for the estate to the taxing authorities. They can pay the second half all the way up until the delinquency date, and the lien stays there. It's their choice, but the 4 taxing authorities, way too many, and 2 law firms. So we'll figure it out.
All right, well, we'll clean up the order one more round of things that I saw as I was reading, and then we'll circulate that to council, and then I'll await signing it, knowing that the closing is on the 31st. And wonderful job. Don't have yet. All right, we are adjourned. Thank you.
Thank you, Albert.
Thank you, Your Honor.